that. We also ask that if you have any topics that you would like to hear from us on our webinars, we would love to hear what those are, because we would love to address any questions, any topics that you would like to learn about. We're more than happy to address those for you. So without further ado, I'm going to turn this over to our presenters, and I'll turn that over to Kayla Washington. Thank you.
Good morning, everyone. Sorry, give us 1 second.
Good morning, everybody. This is Victoria Hill. The universe has decided that you do not get to see me on camera today. I don't know why. We're having some issues, but I wanted to say good morning. Welcome. Thank you so much for joining us. Kayla and I are looking forward to sharing this information with you. And I think she'll be back on in just a second. I'm going to pop on and say hi so you know I'm real. But I will be off camera. Thank you.
Okay, sorry about that, everyone. All right, Victoria, did you want to still pop on? Did you want to pop on?
Oh, go ahead. Okay. Just wanted to say good morning, everybody. Thank you.
All right, so we're going to go ahead and get started. Today, we are discussing legal obligations under FEHA and ADA in regard to disability accommodations. So just a quick legal disclaimer, the information and material in this presentation should not be construed to be
Not hearing anything.
legal.
Turn up volume.
Let me see. Let me check again. Can everyone hear me?
Yes.
Okay, perfect. Thank you. All right. So today we're going to be discussing legal obligations under the ADA and FEHA, more specifically regarding reasonable accommodations.
Oh, yeah. I'm on a webinar.
Like I
I just need to
mentioned,
listen, okay?
it's going to be a legal disclaimer. The information and material in this presentation should not be construed to be legal advice at all, or the formation of an lawyer-client relationship. So just to go through a bit of background with both, the ADA stands for Americans with Disabilities Act, which is a federal law. California has their own state law version, which it has a broader application, and that's FEHA, so Fair Employment and Housing Act. Sometimes we think of this when we think of our sexual harassment training or protected categories, such as race, national origin, color, gender. So the Fair Employment and Housing Act and Americans with Disabilities Act are two critical laws that really protect employees with disabilities from discrimination. So like I mentioned, FEHA is a broader protection. It's more extensive than the ADA, and that's specifically for California employers. So it applies to employers with 5 or more employees, while the federal ADA applies to employers with 15 or more employees. So really the key difference between the two is that under the ADA, a disability that's covered is a physical or mental impairment that substantially limits a major life activity. It's a bit more difficult to prove than FEHA, which is just a disability that's physical or mental impairment that just limits a major life activity. California purposely didn't include substantially to allow for more medical conditions and disabilities to be covered under the state law than the federal law. So, what is a reasonable accommodation here? Victoria, do you want to go ahead?
Okay. Everybody hear me okay? Okay, perfect. So basically, a reasonable accommodation is a job modification that allows an applicant or a disabled employee, a mentally disabled, physically disabled employee to perform the essential functions of the job, right? So we're looking to how can we allow this applicant, this employee to successfully perform what we need them to do in our companies. And if we go to the next slide, the Department of Labor kind of breaks it up into 4 categories, and you can see they're listed on the left. Physical changes, accessibility technologies, accessibility communications, and policy enhancements. And some really practical examples, as you guys likely may know, it's really easy if you have an applicant or an employee that's in a wheelchair, right? That's a physical change would be maybe you have to make a ramp. Maybe you have to make your bathroom ADA accessible. Maybe you have to change the layout of your workspace to allow that person access. That's a physical change. And then there's technology changes. There's a lot of software that is available to help an individual with disability perform the essential functions of the job. There's screen readers, right? There are all kinds of magnifiers for individuals that have sight issues. There's all kinds of software for whatever the issue is. Let's say an individual has, sight limitations. There'll be software that can read it to them so they can perform the essential functions of the job. Video phones that facilitate communications with a deaf colleague or a deaf applicant. That's what they mean by technological stuff. Communications, sign language. The EEOC is going to want you to provide an interpreter or closed caption for meeting or events for your employees. They recognize that already as reasonable. And so I'm getting a little bit ahead of myself, but there's all kinds of information on the internet for you. If you have questions like what's reasonable, let's say you have an employee that has an autism diagnosis or at least symptoms of autism that you're aware of, right? You can go look at the EEOC, or we put it up here. You can look at JAN. It's askjan.org. That is very, very employee, their whole goal is to advocate for employees with disability. So kind of recognize that. But they will list out reasonable accommodations for you. The EEOC will tell you, this is what we expect as reasonable. So if you're ever unsure, obviously you can reach out to counsel for help or your consultants through CalworkSafety. But know that there's a lot of resources that can help guide you on the internet and reliable, and trustworthy sources. Policy enhancements. So, let me go back to communications. The EEOC is going to expect that if you have an individual who is blind and they can perform the essential functions with assistance, that you provide things to them in Braille. They've already determined that's a reasonable accommodation for most employers, right? I don't want to blanket it, but for most employers, you're going to need to provide that accommodation for an individual. A good example of that is there was a case where someone who was blind applied for a marketing position, and the employer was like, well, how are you going to do your job? Because reading is sort of essential. And the employee said, I can do it if you provide it in Braille. Turns out the employee was incredible in their marketing position and really made significant contributions to the employer. They just needed to make that adjustment. The last thing is policy enhancements. You know, a lot of employers don't think about this, or that's a reasonable accommodation. One of the things we're seeing a lot, at least I'm not sure about Kayla, is employees want to bring their service animal to work. And a lot of my clients have been like, hey, we can't provide for that. We don't have an area for the dog to go to the restroom. We don't have, but they need to rethink that, because I think the EEOC is considering that as a reasonable accommodation. Adjusting work schedules, going to part-time, working from home on occasion. Those are the policy enhancements that you'd need to consider. We also have some other examples up there. I think we've talked about them. A leave of absence is a reasonable accommodation under certain circumstances. So we'll kind of get into later on how you work out the analysis, but these are just some examples to kind of get you thinking. Which I went over some of those already, right? I can tell you right now, if you have an employee who's sensitive to light and you refuse to change the light bulbs, that's going to be an example of being unwilling to perform a reasonable accommodation. There's noise abatement. Providing headphones is something that the government feels you must do if you have an employee that has noise concerns. And we already talked about these calendars and planners for individuals that have disabilities that impact their memory, like PTSD or severe anxiety. And ergonomics we talked about as well. So I hope you're not getting overwhelmed, right? Because I know as an employer in my previous life, having to accommodate some of these things are expensive and they're a little bit overwhelming, and I'm busy running a business and I don't really have time to do all that. So the good news is not everything an employee requests, especially in California, is a reasonable accommodation. So accommodations are not meant to be an undue hardship. They're not meant to take away an essential function of the job. An example of that is you have a copywriter position, for instance. An essential function of that job is reading, right? So if someone comes to you and they're unable to read in that position, that's an essential function. That job wouldn't exist if you couldn't read, that job wouldn't exist. So that may be a situation where in that job, you don't have to take away the essential function, or you don't have to provide an accommodation. You don't have to lower your standards. You don't have to create a safety hazard. And you don't have to create a brand new position if a vacant position is not available.
So like Victoria mentioned on the previous slide, an accommodation isn't meant to create an undue hardship for a company. Of course, California has defined what an undue hardship is, and it is considered something that would be significantly difficult or expensive to provide. And actually, both the FEHA and ADA acknowledge that some accommodations aren't feasible, as they can either be overly difficult or expensive, like it mentions here. So employers must be able to show that it would really pose a significant, and again, I feel like there's a key word, significant difficulty or expense. It's not just that, oh, something's kind of expensive, we want to go with another option that might be less effective for the employee. So to really determine whether there is significant difficulty or expense, what a court will look at and what an employer should look at when kind of trying to make this determination is the nature and cost of the accommodation. So is the accommodation, I don't know, $5 and you're a small company that can afford that, or are you a small company and the accommodation is $10,000? The employer's ability to pay for the accommodation, the type of operations that are conducted at the facility, and the impact on the operations of the facility. So kind of what that employee's role is, their role within the operations of the facility, and of course how their role intertwines and how that would have an impact on the facility and that accommodation that they are requesting. So the number of employees and the relationship of the employees' duties to one another. So does this employee have similar job functions that overlap with a coworker? In which case, maybe we can provide them some type of accommodation in which some other coworkers are kind of doing the same job, so it won't be a huge burden or difficulty for the company's operations. The number, type, and location of the employer's facilities. Is this a big company that has maybe 5 different locations, or is it a small mom and pop one location type of place? The administrative and financial relationship of the facilities to one another. Are they all kind of under one entity? Are they separate entities? These are all things to really look at when trying to determine what an undue hardship is. So unfortunately, it's not a clear black and white, this is an undue hardship. There's a lot of gray area in here, and the court really does look at all of them and weighs them all pretty equally. So, like I mentioned, an employer has to have a stronger defense than just stating that the accommodation would have been expensive. Really has to show why and how. So, not that it's just a mere inconvenience. So, I think sometimes it's easier to present maybe some real life examples. So, a company with 10 employees and really limited financial resources is asked to provide a 50,000 ergonomic chair to accommodate an employee with a disability. That would likely be considered an undue hardship because the cost and equipment relative to the company's size and revenue could be considered very high, and it could significantly impact their operations or their finances. So also if the equipment's really highly specialized and wouldn't be useful to any other employees, that's something else that you can also take into consideration. And on the opposite end of the spectrum, an employee maybe with a chronic health condition, if they request flexible scheduling, maybe some remote work here and there, so they can attend medical appointments. So maybe if they request like a 3-hour lunch break every Tuesday and Thursday to attend these appointments, that's likely not going to be considered an undue hardship because you're modifying the employee's work hours. It's likely not going to be a huge cost for a large employer, and it wouldn't disrupt the company operations too much. Also, if this still allows the essential functions of the job to be performed, then it would likely need to be granted and wouldn't be considered too much of an undue hardship, if any at all. So, what isn't considered a reasonable accommodation? Victoria touched on this, and just to kind of reiterate, like we mentioned, undue hardship, small to medium company having to hire a full-time employee to assist a disabled employee. If we have to hire a whole new person at salary, benefits, that could be very significantly expensive for a small to medium-sized company to help a full-time employee or assist a disabled employee in some way. So with requiring the removal of an essential function, some examples are a data entry position requires 100% of the day to be on the computer, entering data, and now the reasonable accommodation, it's asking it to be cut down to 30%. So that's essentially removing an essential function of the position. Or maybe a delivery driver that's no longer able to drive due to a disability, maybe epilepsy, something of that sort, or medical condition, in which case the delivery, that's the whole entire point of the delivery driver, and they can no longer drive and do that job. Therefore, it's likely that we're removing an essential function. With displacement of a fellow employee, that's really referring to a situation in which accommodating one employee's needs would require removing or significantly altering another employee's position or responsibilities. You're not required to do that either as a reasonable accommodation. We also have accommodations that provide more paid leave to an employee with a disability than other kind of employees at the workplace. So offering more paid leave solely to an employee with a disability could be viewed as creating inequity among employees and isn't required. Creating a permanent light duty position, that almost could fall into requiring removal of an essential function as well. If you're finding that now maybe it's like a manufacturing position, there's a lot of heavy lifting, they can no longer do any heavy lifting, and a temporary light duty position may be a reasonable accommodation if it's something like a broken arm that we assume is going to get better with time. If it's something now where they can no longer lift anything over 5 pounds, then at that point, we're not required to create this permanent light duty position. Another one is accommodations that could endanger health and safety of an employee or others in the workplace. This is another issue that sometimes comes up when an employer requests a reasonable accommodation. So when we're thinking of the health and safety of employees and others in the workplace, I think it's important that we think of the danger and the threat, because at that point we'll want to consider factors such as the duration of the risk, the severity of the potential harm, the imminence of the potential harm, and the actual likelihood that that harm would occur. We can't just say, oh, well, we think that possibly this could affect the health and safety. We're going to want to look at some key factors that the EEOC and courts look to. I did want to actually go back to requiring removal of an essential function, just because we might be unfamiliar with what really is considered an essential function of a job. So some factors also to consider when determining whether a function is essential would be like the reason the position exists in the first place, maybe the number of employees who are able to perform that specific job, as opposed to just a marginal function. So an example of a marginal function versus an essential function, if we go back to the delivery driver, an essential function is his ability to make these deliveries, maybe some type of physical heavy lifting requirements, his ability to drive. A marginal function might be that he has to assist in filling out paperwork when deliveries are slow. If he can no longer, assist in that paperwork, or maybe he has to answer phone calls when the receptionist is out, that's not considered an essential function. We could remove one of those functions if a disability that he has prevents him from doing those. Those are marginal functions at that point, and that wouldn't be considered unreasonable to kind of remove those if his disability requires that.
Okay, thank you. The interactive process. Employers must initiate we're going to go over when employers need to initiate, because sometimes it's a little bit confusing. Obviously, if an employee comes up to talk to you about some issue they're having, or disability, or time off, they're initiating the interactive process. They may not know it, right? Those are words that probably HR management's going to use. But really the question is, when they don't initiate it, what's your obligation as an employer? And the answer is, if you have information from a supervisor, If you have information, sometimes you get it from a family member or a coworker. Sometimes the spouse will call in. If you notice a substantial decline in the employee's performance, right, you are now sort of on notice, and you then have to engage in this quote unquote interactive process. And we're going to talk about exactly what that is. But you don't have to wait for the employee to tell you. And in fact, the employer has an obligation, if you know or reasonably know, or you've somehow been informed, especially by a supervisor or a manager, the knowledge that a supervisor or a manager has will be imputed to the employer. So if you have any question about whether to approach the employee or not, I know a lot of times, at least my clients feel a little sensitive about it, or a little bit, they're cautious. They don't want to say the wrong thing. They don't want to create liability for the company. But if you choose not to do that, right, you are creating a liability for the company. So kind of look at it like, do I know, should I know from the circumstances surrounding it? And then you have an obligation to talk to the employee. Sometimes also, if the employee goes out on a workers' comp claim, obviously you're going to engage in the interactive process when they want to come back to work, right? Maybe they're on an FMLA. Maybe they ask for time off for medical care. All of those things should immediately trigger in your head, okay, I got to pay attention here and engage with this employee. Okay, I think we're good. You want to, as we go to the next one, when you're engaging in the interactive process, you want to act promptly. You don't want to lollygag around. I know I've had situations where HR is saying to the CEO, hey, we got to do this. We got to talk to it. And the CEO is busy and she says, I can't deal with it now. I can't deal with it now. And pretty soon, a week, 2 weeks, a month goes by. And so you don't want to let that happen. You got to ring the bell and say, hey, the law says we have to do this promptly. All right, so what is the interactive process? Really, basically boils down to talk to your employees. The interactive process means you're communicating with your employees. You're asking them about what's going on in their life as it relates to how it's affecting their ability to perform the job, right? And this, as I mentioned, it needs to be timely. It also needs to be done in good faith. So if your CEO or your manager comes to you and says, oh my gosh, I cannot stand this employee, we need to get rid of them, I think they have a disability and they can't do the job, let's terminate them, right? And you explain, hey, we have to engage in the interactive process, we have to talk to them, we have to do this. And the CEO says, fine, do what you need to do, but at the end of the day, we're going to terminate them, right? That is not really engaging in good faith. And in fact, I want to share with you, not that Kayla and I are looking for more work, because we are blessed with lots of work, but that conversation between you and the CEO or whomever it may be, that's all discoverable. If this situation goes bad and the employee files a claim and you're called to the witness stand, you're going to need to testify to that conversation. Guess what? Case over. Employee wins big money, right? Because right there, your company is not demonstrating good faith. So I want to suggest to you, if you have that situation, and your whomever it may be, CEO, manager, whomever, you stop them right there. You explain, hey, this is what the law requires. It's very simple. We talk to the employee. We analyze, we figure out what they want, what they're asking for. We analyze if we can do it. We come to a decision and we talk to the employee. And there's all kinds of options that can happen at the end of this, right? It may be that we grant them the accommodation. It may be that it's an undue hardship and we can't. It may be that we part ways, right? It may be that we end up at termination. I don't know, but that's just something that's down the line. If you do that, you're preserving the conversation, you're preserving the good faith part of your obligation. I would like to say, if you do find yourself in that situation, it's probably good to reach out to counsel, because if you're discussing things like that with your CEO and your counsel, it's privileged. So that's just a little, right? Some of these claims can get kind of lengthy in litigation, expensive, and sometimes they get a little ugly down the line. So if you have the privilege of having a lawyer assist you, whether it's any lawyer, right, assist you in this process, if you think it's going to get tricky, you might want to consider that. Okay, so kind of getting back to you, the employee also has a duty to cooperate with you. If the employee doesn't want to cooperate with you, it's a little bit tricky. But one thing you want to do is document. You want to say to the employee in writing, hey, you have this obligation to talk to me, to talk to the company. We want to help you. And, how can I make this easier for you? What can we do? At that point, if the employee still refuses to cooperate, one of the things I've done, I've said to the employee, look, if you don't want to talk to me, can I talk to your doctor? I'm not going to ask what the diagnosis is, but I'm going to engage with your physician so that I can understand what your limitations are and how the company can help you. Okay, so that's another suggestion. But really, the basic bottom line is the interactive process is essential to defeat a potential claim that the employee is going to bring down the line if you can't resolve it, right? They're going to bring a claim for failure to accommodate. And if you did not engage in the interactive process, you lose. I'm just straight off the bat, you're going to lose. So we want to engage in this process, one, to do the right thing, two, to protect the company down the line in a claim. Okay, so what is the interactive process? We just talked about that. How do you successfully engage in it? As Kayla mentioned about your job description, one of the most important things that we can share with you today is having an accurate job description. Not all functions, as Kayla mentioned, are essential functions. You really need, and the reason a job description is so important is because, and Kayla's going to talk about the medical documentation in a bit, but your employee takes that job description to their physician. And the physician says, and you ask the physician, look at this job description and tell me if the employee can complete it with or without essential functions. So if you don't have the job description, all you're relying on is the employee going to the doctor and saying, yeah, I can do this job or I can't do the job. And the doctor, he or she is in the dark, right? So they have to have the good job description, and it needs to list the physical requirements. This is really, really important for applicants. If you get an applicant who wants to come in and do a job and they have an obvious physical limitation in performing that job, you really don't have a lot of protections initially unless it's written in a job description. Right? So what are the physical requirements? Do they have to be able to have repeated movement? Do they have to be able to bend and lift and all that stuff? So typically in a job description, I'll have the essential functions, I'll have important skills and requirements, wishes and wants, and then I have the physical requirements. Okay, let's see. I think that's about it. If you have any questions on the essential functions, your CalWork Safety HR person consultant can really help you with that, because they're super good at analyzing that and creating good job descriptions for you. Yeah.
Okay, and like Victoria stated, I'm going to be discussing a little bit about medical certification. So, as Victoria mentioned, I think clients are a little hesitant when wanting to ask for medical certification, although it's well within your right to do so with some parameters. So you can request a medical certification if the employee's disability is not obvious. So some non-obvious disabilities that I've actually seen a really big spike in with my clients personally, things like anxiety, ADHD, autism, like Victoria mentioned previously. Also, some other ones like epilepsy, fibromyalgia, where we cannot actually see and know for certain what the limitations are, and which we'd really like a doctor's guidelines as to either the limitations of the job, what the employee can and can't do, and just some further information to maybe even discuss whether or not it is a disability. So with that, I don't want to say like if the condition is obvious, like, I don't know, if maybe someone has a broken leg, we can obviously see that their leg is broken, they're going to require some accommodations, but we might wonder kind of how long is this kind of a temporary situation? How many months are we looking at? How can we best accommodate this employee? Or maybe if you see an employee with a cane, how long should they be standing? How often do they have to take breaks? This would also be good questions to ask a medical provider, even though we can see the disability or the injury, but we kind of want to know a little bit more as to the limitations the functional limitations and the need for an accommodation, that's a point where we could also request medical certification and kind of narrow our questions down to specific job and business reasons and necessity. So what should the medical certification include? This is something that I also see frequently, is that you will ask an employee to provide some type of doctor's note regarding accommodations or limitations, and the doctor maybe puts one line in there stating that the employee is temporary disabled, leave of absence. And that's pretty much it. So you might look at that and be concerned and confused. You can always go back to the medical provider and ask them to clarify or ask them to provide more information. So the medical certification, to be considered really complete in the interactive process, should include the name and signature of the medical provider. You want to make sure that this is a person who's qualified to evaluate this employee in this circumstance. So for instance, if they're having maybe psychiatric issues that they need reasonable accommodations for, but they're getting their certification from someone who outside of a psychiatrist, maybe if it's like a chiropractor or some kind of doctor that's not, or medical provider that's not dealing with mental disabilities directly, then that could be a situation where we may want them to go to a different provider. So I think the name and signature of the medical provider is very important. The medical provider's verification that the employee does actually have a disability. It's as simple as them just understanding what that definition of a disability is under FEHA and just stating that the employee does have a medical condition or physical or mental impairment that would be considered a disability. We absolutely do not want to request the diagnosis, and I put that in like bold and underline, because we are not entitled to the diagnosis, and FEHA specifically prohibits employers from asking for the diagnosis. We'll also want a description of the employee's limitations in relation to the employee's job. This is why it's so vital and to have the actual job description to give the employee, and like Victoria mentioned, so important to have the essential functions listed and kind of other functions, like she said, her wishes and wants in there as well. So that way the doctor understands what the employee is doing on a day-to-day, week-to-week. Also, this kind of helps kind of supplement the employee's telling of the doctor as to what they do typically, as that might not be as accurate as if we also provide the doctor with a job description that they can review with the employee. So we'll also want whether those limitations are permanent or temporary. Are we going to have to check back in 6 months because these are only temporary job accommodations, or are these more permanent? And this is going to be an accommodation that we're going to have to provide throughout the tenure of the employee's stay with the company. So if the limitations are temporary, it should state when the limitations are expected to end. And then also recommendation of reasonable accommodations given the limitations. So it's important to note that you're not bound by the accommodations set forth by the doctor. So these are accommodation ideas, not requirements. You still, once you receive that medical certification, you're still going to be discussing with the employee, speaking to them. Maybe there's an accommodation that their doctor put in there that they don't feel would benefit them. Really, the employee knows their condition and their disability and how that limits them from performing in certain aspects of their job. They're going to know that best. They're going to know that better than us as the employer or the doctor. So I think it's also important just to understand that that's really looked at as a guideline. It's not necessarily, it's not the same at all as when a doctor provides work restrictions for a worker's comp injury, in which case the employer must assign work that meets those restrictions. This is a different part of the law where these reasonable accommodations that they're suggesting are guidelines. And I mean, if we're not going to be able to provide those accommodations, and that's also what the employee's requesting, that's when we kind of go through that analysis of whether it's an undue hardship or endangering the safety of the employee or other employees that are at the work site. And that's a time when it would be great to get your legal counsel involved, because like Victoria said, all those discussions to kind of analyze and figure out which accommodations can or can't be given. Those can all be protected.
Is this me, Kayla? Okay. Discuss with the employee. So one of the things you want to go over the job description with the employee and you want to ask them, do they think they can meet the essential functions? I can almost guarantee you every employee is going to tell you they are excellent at their job and they can meet the essential functions. And if not, the idea is to get a list from them of what they need. And if they can't give you a list, you kind of work through it with them. What do you think you need? If you can't perform it, what do you think you need? I do like to use those exact words, the interactive process. And I really just explain it to the employee. Hey, right now the law requires us to engage in the interactive process. It requires you and me as your employer to do it. And the reason I like to use specifically those words, interactive process, is that hopefully everything, knock on wood, everything's resolved, the employee does well, the company does well. But if it doesn't and the claim goes bad, they're going to go to a plaintiff's lawyer. And the first thing the plaintiff's lawyer is going to say is, did they engage in the interactive process? And most employees aren't going to know what that is. But it might ring a bell. Oh yeah, they told me they did, right? Because if you don't engage in the interactive process, as I mentioned, that's, can potentially be a slam dunk. So I do like to use the words interactive process. And I tell the employee, it just means we're going to talk. We're going to talk about this. It's also okay, in my practice at least, to talk to the employee about where I think they're falling short. So if I had an employee, for instance, it was an employee with autism, fairly high functioning, but as we went through the job description, he literally thought he had a 10 on everything. The company evaluated him really at a 2 or 3 on, I would say, 60% of the essential functions. And he had a very difficult time, one, understanding that, but two, I wanted to discuss that with him and go over it with him, or have the HR manager do it, so that he understood where the company was coming from. So he had a realistic basis of what this interactive process was going to look like. You want to communicate a timeline to them depending on what the issue is. I think we'll be able to get back with you in a couple of weeks on this. If the employee's home and it's unpaid, you want to hustle. You want to jump on this and work on it as fast as you can. If the employee is working, the supervisor's 80, 90% satisfied, you can go to a little bit slower pace. You still need to be prompt, and I would resolve it as quickly as possible. There's a Microsoft case, and in that case, this employee asked for 10 things. And, he asked for accessibility, technology, software. He asked for some new policy. He asked for different lights and headphones. Microsoft gave him all of that. One of the things he asked for was a full-time admin assistant to read his emails. And this was at a high level position. And Microsoft said, we can't do that. And they went back and forth for a couple months. And at the end of it, they said, look, we're going to put you in this program where we can reassign you. Microsoft, obviously, huge company. We can find a position. And he said, no, I'm not going to do it. I want an admin to help me do my job. Ultimately brought suit. And the court found in favor of Microsoft. They said, you engaged in a 2-month discussion with this employee. You granted most of his accommodations. You explained why he couldn't have the ones he wanted. You went through the undue hardship analysis. And the employee, the court found 100% for Microsoft. So that's kind of the ideal. I kind of looked at that case as, what am I doing? How am I taking care of the employee and representing the company? One of the last things you can ask, and I know a lot of my HR friends are afraid to ask, is how can the company support you? That's a Don Dressler. If you guys know Don Dressler, that's a Don Dressler, right? How can the company support you? Sometimes when I ask that of the employee, I literally see their shoulders drop. I see them start to relax, and they immediately think, okay, my employer cares about me, right? So if it's not a predatory employee or candidate, they're going to be so much more likely to engage and discuss with you in a productive manner. Next slide, please. All right. So we kind of just talked about this. You're going to be discussing with the employee, and then you're going to be discussing internally, and you're going to be analyzing the requested accommodations. Kayla's going to go through a form that's just, it's a complicated form, but if you analyze it according to how this form is laid out by the Civil Rights Department, you absolutely will be able to defend your decisions. Because really what the EEOC and what courts are looking for is you had a good faith engagement in this process, right? And so in analyzing it, you want to go through whatever resources you have based on whatever issue it is. I had an epilepsy issue, and it was really a safety issue. So we had all kinds of analysis that we could ask ourselves. Kayla went through some of it. Is it a direct threat to the employee or to others? And you analyze it that way. You want to document how your analysis. You want to document why you can't give the employee the accommodation, why it's not reasonable. If you can give it, awesome. Hey, employee, we're so stoked to get this for you. We got you this chair. We changed the lights. We got you this software, right? And then you want to document that as well. Remember that any documentation regarding this stuff is medical, and it needs to be kept in a separate file. You're not going to want to put it in your employee's file. You're going to want to keep it separate and confidential and privileged. If you reject the employee's accommodation, again, you want to be able to tell them what you did to get there. We analyzed it. We looked at this. We talked about it. We can't do it. Here's what we can do. Or we can't meet this, but, let's talk about what we can do next. You can go ahead, Caleb, to the next slide. This is an ongoing process. I had one client who his restriction was he wasn't able to fly. Something happened. He was diabetic, and something happened when he flew, and he was an outside salesperson, and travel was a huge part of his job. So the company agreed that he could travel by car or train, right? But that they had to review it every year. Well, for the first 2 or 3 years, they reviewed it, but then the company stopped. The employee started to get disgruntled. And the company, so then he brought it up maybe 2 years later, and the company's like, hey, you didn't engage with us. We're no longer going to offer you that accommodation. Well, he filed a claim and was successful, right? Because the obligation to continue this interactive process is both the employee and the employer, right? And so the employer can't push it off on the employee. Ultimately, it's the employer's obligation, I think, to continue to have the conversation. I like to document every conversation I have with an employee because if it goes bad in 3 or 5 years, A, you may not be there. 2, likely if you're called to the stand, you're not going to remember. So I spoke with John. I spoke with Susie on this date. We talked about this. Here's how we resolved it. Follow-up date is what? It's all the basic stuff we know, but we get so busy and don't do it. So it's good to have a reminder, at least for me it is. Okay, I think I'm good.
So like Victoria mentioned, the Civil Rights Department has a great packet that's helpful for employers who are going through the interactive process. So I've went ahead and copied each page on these slides just so that way you can take a quick look. It's really, I think it's called the Reasonable Accommodation Packet. So if you just look up California CRD, Reasonable Accommodation, it should pop up. There's a version in English and Spanish as well. So it's very helpful. That's section A. That first page, that's all completed by the employee. So the employee is essentially requesting the accommodations that they need. It asks for the employee to be as specific as possible, which is what we'll want and which will help really facilitate more effective communications once we do have that discussion with the employee. We also want to know the reason for the request. We're not asking for the diagnosis. Again, very important, and I like that this form reiterates that here. We just want to know how the accommodation will help do your job. So maybe they say they get headaches with bright lights or loud noises, kind of touching on that migraine before. So maybe if they just say reason for the request are headaches and the accommodation requested is switching out light bulbs. It would be as easy as that. We're going to ask whether their limitations are permanent and temporary. We're also going to want to know whether their disability is the subject of a workers' comp claim. We'll want to have them list that there. And then that also puts us on notice if we weren't aware that there was even a workers' comp claim with an injury or illness. That kind of alerts us that if we haven't already, we give them that DWC-1 form. We're also going to want to ask them whether they are requesting any type of leave, because of course, this will trigger other obligations. If they're requesting CIFRA or pregnancy disability leave, then we'll have to kind of look at whether they qualify. We'll have to send designation notices. So this really is helpful to determine where the employee is coming from, their headspace, and really provide some helpful background information. That section B is what we'll want to give them to give to their medical provider. So again, it's going to ask for verification that the employee has a disability. It also reminds the medical provider not to disclose the diagnosis, which is also very helpful. I like that it again in there says that you should provide the employee with a copy of a job duty statement, some type of job description, just so that way we have that as a reminder that we'll want to attach a job description to that section B. So that way when the medical provider is filling that out, they can also see the job description and can go over that job description with the employee. So we're going to want to have all of that information 1 through 3 provided there. They can add extra pages if they'd like. It also has spaces to let doctors let us know, or healthcare providers let us know when that accommodation begins, when it ends, and has their name and signature section provided as well. So now with section C through E, that's where it's really helping us with those discussions. So we're going to want to have all of our discussion notes in there, extra pages if needed. It's kind of small spaces, so we'll likely need some extra space. We're going to want to list all the potential accommodations that were identified through that discussion with the employee, whether that be from some of the doctor's notes, from the employee themselves, what we think would be helpful as well from kind of a business operations standpoint, and what we just think is effective. We'll want to have all that there with strengths and weaknesses. And with 3, we're going to want to state the recommended accommodations and our rationale for those recommendations. And still, like I mentioned, that section C, that's all completed on our end as the employer. Section D also completed on our end. That's where we're now thinking of what accommodations we're going to be implementing and which ones we've rejected. So we're going to write down the specific accommodations that we plan to implement and that we're going to provide. And then we're going to want to explain the reason for the denial of any of the employees' specifically requested accommodations. So it lists out the reasoning there. So it says that it'd be ineffective, cause undue hardship. It wants us to specifically identify the hardship. Medical documentation inadequate. That's another thing. If their medical documentation, if they're requesting, they maybe have some sort of anxiety and they're requesting maybe 2 extra 10-minute breaks throughout the day when they're feeling maybe overstimulated, overwhelmed, but nothing to the doctor's notes state anything about needing extra breaks, then maybe we'll want to say, hey, this extra rest break situation, the medical documentation currently is inadequate. We'll provide you with some more time if that's truly an accommodation that you think will help you with your job and isn't an undue hardship on us. We'll allow you to go get further medical documentation from your healthcare provider that specifically lays that out or gives us some information regarding your limitations to the essential functions of your position. That kind of just really helps clarify for us that that is something that you'll need. Another, like we mentioned, removal of an essential job function, lowering or performance or production standard. If it's a safety issue, like I talked about and Victoria mentioned again on her slides, we can put that in other and just put that this is the analysis we did in that further explanation and comments area, just to let them know that we are supporting them. Any denial shouldn't be seen as kind of a flat out denial, but just that maybe some accommodations that they're requesting don't necessarily work on our end for the reasons provided, but we are happy to provide X, Y, and Z. So it has the dates in there for you to fill out, which are helpful as well. And then we have section E, which really helps to document all the interactive discussions. Like Victoria mentioned, this isn't just a one and done, it's an ongoing conversation with the employee. So say we implement the changing in light bulbs and we give headphones for any type of noise abatement. And we check in, maybe we check in a couple months. We ask them how everything's working. And maybe they say, hey, these headphones, these noise canceling headphones aren't so great. I can still hear a lot of noise filtering in. And so we get another set, maybe a different brand, or maybe everything's working out well, everything's great, but we still mark on there that we checked in, we spoke to the employee, they let us know either that the accommodations were or weren't working, and kind of what steps we took to either provide different accommodations or that we made a note that we'll follow up again in a couple months if everything seems to be working okay. All right, so now we're going to open it up to any questions.
I think Nora has a question in the chat.
Yeah, so I got it. So Nora asked, can a severance agreement protect the employer if an employee will resign after the interactive process and they just want to stay home? So a severance agreement could protect an employer in this situation if, yes, if an employee does have a disability and maybe they're not looking to engage in the interactive process. If not, then like Victoria mentioned, we'd want to document everything. If we're worried that some claims might arise, this would be a good chance to speak to legal counsel to see if there's any liability or risk in terms of the employee's tenure with the company, if there's any kind of other claims, or maybe if we didn't handle the interactive process well, maybe if we didn't get started on it on a good foot, or like Victoria had also mentioned, we didn't do it in good faith, then maybe we do want a severance agreement just to cover us from any claims that might arise down the road. Victoria, do you have anything else you'd want to add to that?
No, I think you covered it. Thanks.
Any questions, anyone? turn off here? Yeah. Okay. Well, thank you so much for attending our webinar. We greatly appreciate you. And of course, we appreciate our presenters. Thank you so much to Victoria Hill and Kayla Washington. We look forward to seeing you in 2 months in December. We're going to have a webinar on the legal updates for 2025, and we look forward to seeing you then. Thank you so much for participating in our webinar today, and I hope you have a great holiday season, and we look forward to seeing you in December. Thank you so much. Take care. Okay.